A Crimora business just beat Augusta County in court, and taxpayers might want to pay attention to what it cost them. The Virginia Court of Appeals has handed a major defeat to the county in its case against Mad Properties, a small auto repair and sales business that's been around since the 1930s. The issue: whether a few untagged cars sitting behind the shop violated the zoning ordinance. The county claimed the vehicles were inoperable and in violation of a 2017 permit. The business owner, Mark Baber, said they were awaiting repairs or had already been moved. He also argued that the county had allowed this kind of work on the property for decades. In other words, this was just a local garage doing garage things. But when the case reached trial, the judge didn't even let Baber make that argument. Citing something called the thing decided doctrine, the court ruled that because Baber didn't appeal a zoning notice from 2 years earlier, he had lost the right to ever challenge the county again, no matter what had happened since. The Court of Appeals said not so fast. In a detailed opinion, the court ruled that the county and the trial court got it wrong. Property owners have the right to either appeal a zoning notice or fix the problem. They don't lose all rights forever because they didn't file paperwork in time. The court also pointed out that Augusta's own inspectors had, on multiple occasions, found no violations on the property. Yet the county sued anyway. Worse, the zoning ordinance clearly allows vehicle repair businesses to operate in that zone, meaning Baber was being sued for doing something he had every legal right to do. So now, the case goes back to the trial court, and Baber finally gets the chance to present his evidence. But the bigger question is this: why was this even a lawsuit? Because this wasn't just a legal misstep, it was an expensive one. Every hour, county attorneys spent drafting motions, every zoning inspection, every court filing, that all came out of the county budget, which means it came from you, the taxpayer. And if Baber requests and wins attorneys' fees for having to defend himself, guess who'll be footing that bill too? When the county loses in court, you pay both sides of the fight. This isn't just a zoning story. It's a story of what happens when the government sees itself as adversarial to taxpayers. And the moral of the story is simple. Don't take small businesses to court unless you're really sure you're right. Because if you lose, it's not just your legal theory that falls apart. It's the taxpayers' money that goes with it. And in Augusta County, this isn't the first time taxpayers have been left holding the bag so that our lawmakers can go about their own agenda. So, if you see a rollback truck parked out back, or a dusty old vehicle waiting for a fix, just know, it might not be a zoning violation. But if the county sues again and loses, that's most definitely a violation of every county taxpayer. To stay up to date on the latest in local government news, subscribe to Breaking Through News on YouTube or at breakingthrough.com.